Let's get started, everybody. So my name is Ariel Goldberg. I'm a partner at Stradley, Ronon, Stevens & Young in Chicago, and I'm thrilled to be on the panel with my co-panelists. To my immediate right is Kevin Ehrlich from Western Asset Management. To his right is Jeff Engelsman from TCW Group, and to the far right is Wendy Fox from Ariel Investments, again in Chicago. So we are going to talk about institutional client intake. When we were preparing, we all said to each other that it would be great if you folks had questions for us. We can talk for hours up here among ourselves, but we think it would be best if you have questions, raise your hand, interrupt, throw things at us. It'd be great to have a conversation. I always find that I learn from questions from the audience, and I think it would be a much more interesting conversation. So please, 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 do not be hesitant. So our topic today is institutional client intake. My role here as a moderator is to set the table. When we were preparing for this, I am the lawyer, the outside lawyer on the panel. When I was thinking about the panel, I pulled out my Investment Advisors Act rulebook and tried to find a page on where there's client intake and couldn't find anything. I couldn't find anything in the Investment Advisors Act, so I said, goodness, why is a lawyer moderating this panel? That's not a legal basis. But I think what my job is to do right now is to everything that the experts, the operational, so to speak, experts, and I'm not saying that in a pejorative sense, everything that we're going to talk about later on the day is based upon really two principles. And I know in the two panels in two sessions we just had, we talked about the fiduciary rule, but that's really the truth. So everything that is going to be discussed today has its basis and origination from the concepts of the fiduciary rule. So I get to repeat very briefly, unfortunately, some of the precepts from the fiduciary rule that came out this past summer to set the table. And when we go through the topics that we're going to talk about today, I'm going to remind you how all the issues, the practical issues that I think you're here for, are based upon the fiduciary rule. The second thing that I'm going to talk about very briefly is the other reason why it's really important and why a lawyer is setting the table, so to speak, is because it's important for compliance purposes. I think being on both sides of the table, the SEC and now in private practice, it's very easy in 2020 hindsight for the SEC staff to say that something wasn't in place and that you violated 20647 or 38A1 under the Investment Company Act. And I don't think what we're going to talk about, while it's not, no one's going to say you didn't have compliance policy and procedure because you didn't have due diligence policies or RFP policies. It's the same concept. And so again, I think while the fiduciary rule is important, I think the compliance rule is also important. It goes to operational good hygiene as well as complying with the fiduciary rule. So with that table, again, these are the topics we're going to talk about. I'm not going to go over the slide very, very much, but I think you can see these topics. And also the packet, as well as a much longer outline, are in the materials that you can access. So I wanted to make sure that everybody was aware of that. These are the topics we're going to talk about. And I'm going to go into a little bit of depth. I know everybody's heard about it this morning, so I don't want to belabor it, but I think it's really important as to set the table, as I said previously, as to why fiduciary aspects are very important. Again, in June this past summer, the SEC came out with their interpretive release. I sort of disagree with the panel. I think that was this morning. I think it's really important. I think clients really do need to pay attention to it. I think clients I've been advising my clients to go through your disclosures, go through your ADV, go through your policies and procedures. Some of the panelists acknowledge that it's baked into the OC examination process, but I think people really need to take a hard look. And what do they need to take a hard look about in the interpretive release? And it really boils down to, from my perspective and for this panel's perspective, in two issues that we're going to talk about today. One is the duty of loyalty, and the other is duty of care. And when you read those two together, the SEC interpretive release comes out and says that an SEC registered advisor needs to act in the best interest of the client. Now, and if you can distill that statement, acting in the best interest of the client, that has practical implications as to what my co-panelists are going to say. If we break it down into two aspects, again, the panelists this morning talked about two parts. One is the duty of care. And if you look at the bullet points, a lot of these bullet points, advice needs to be suitable, advice needs to be in the best interest of the client. I mean, those two bullet points are really on the investment side. So it's not per se applicable to client intake. So I'm going to go over that real quickly and briefly, which I just did. What I think may be more germane in the SEC interpretive release is the duty to provide monitoring over the course of the relationship. Well, how do you establish a monitoring over the course of the relationship? I think the SEC is going to ding registrants if they don't have monitoring procedures, but what are your procedures going to say? How do you know how to monitor and when to monitor? And I think what we're going to talk about later on today forms the basis of putting together good policies and procedures. So I do think while the duty of care is predominantly on the investment side, the duty to monitoring has some real applicability to what we're going to talk about in just a few minutes. The duty of loyalty with respect to the interpretive release, it does have practical and immediate implications to the topics that we're going to talk about very shortly. And in some, and again, I apologize for the repetition, but I think repetition is good in this instance. If duty of loyalty requires that an advisor make full and fair disclosure to its clients of all material facts relating to the advisory relationship. And it also requires you to eliminate or at least expose through full and fair disclosure all conflict of interest, which might include the advisor to render advice which was not disinterested. Again, good concepts, tying it into client intake. I think if you had to distill it down to one concept, which we'll talk about, and that is disclosing the conflicts of interest and understanding the contours of the client relationship. Well, how do you make sure that you have sufficient disclosure, and how do you make sure that your contours of your relationship are fully disclosed and within the advisory contract, which, again, I'm not going to steal the thunder of my co-panelists. It's by starting these precepts and making sure that you understand the legal setting, and then we'll go into the practical setting. So without further ado, again, the next slide is really just a repetition of what I just said. So without further ado, I again, would like to turn it over to my co-panelists right now. And remember, I'm going to start with those concepts in mind. We're going to start with talking about contracts, and Wendy is going to take us into contract. If you think about what I just said, contracts are really one of the opportunities, in addition to your ADV, for full and fair disclosure. Contracts also will establish the contours of the relationship. So while I very snarkily started my conversation by lawyers leading the conversation, there is real germane points that I just at the table for Wendy to now take it away on advisory contracts.
And so what we plan to do is I'm going to talk about things that I deal with in my shop and how we do it, and then Kevin and Jeff are going to pipe in relating to certain things that are germane to what they do on these topics, and I expect that we will probably get questions from all of you. So the contract process, I'm going to take you through the contract process. It's really important to have a point person who can lead the review of the contract as well as the negotiation of the contract, so that you make sure that your contract that you end up signing is the one that the firm wants to sign. There are two types of contracts. There's standard contracts that every firm creates that has all the things that the firm wants to have in the standard contract. And then there are some clients, and many institutional clients, who don't want to use your standard contract. They want to use their own standard contract. And so when you need to review non-standard contracts, I want to just take you through how we do it at our firm. One, I think it's really important to utilize a checklist for the legal team. At our firm, our legal team is the point person. And for them to utilize a checklist to review the non-standard agreement to see if there's provisions that are missing from the non-standard contract, to see if there's any things that we think are critical to have in the contract throughout the negotiation. The next thing is to make sure when reading the contract that you have all the exhibits that are mentioned in the contract. So if the contract says the IPS is attached here, you want to make sure and the IPS is an investment policy statement, you want to make sure that you have the IPS to review. If it's an ERISA client, often they reference trust documents. Additionally, if it's a public entity client, They will include laws and regulations that relate to the specific jurisdiction in which they reside. And so it's important to collect all of those. Some of those have investment restrictions embedded in them, as well as other reporting obligations. So what we then do is we distribute the contract to key point people throughout the firm. First, we distribute it to the portfolio managers so that they can review the investment policy statement to see whether it's a suitable investment, whether our investment style that they're trying to invest in is suitable for what they want to do with their investment restrictions. We send it to our CFO to review the fees, and specifically, asset-based fees. If we're going to pay in performance-based fees, they need to comply with the Advisors Act. And then if it's MFN, most favored nations fees, we need to make sure that the most favored nations fees comport with what we want to do as a firm with respect to the clients that are being onboarded. Do any of you have any comments on fees or investment restrictions?
Sending it to outside counsel?
I was going to mention something in particular on the investment restrictions. You need to remember that there are different constituencies in your organization. The sales folks want to bring in the money, but it's the portfolio compliance people that have to monitor the guidelines. The salespeople want to bring in the money, but the portfolio management team actually has to be able to meet the alpha targets or get the returns. So if the restrictions are too narrow, they're not going to be able to generate the returns that the client is looking for. So getting a match of expectations up front and then getting the right people in place to be able to code restrictions into compliance systems, things like that, is critical, because you're going to have downstream problems if you don't get that right up front. And some of those downstream problems are going to be really, 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 really expensive. If you screw up a compliance guideline and you have to call that brand new big client a week later and just said, hey, we had a glitch because we didn't correctly nail down your guidelines on day one, that's a really, really embarrassing call. And if you've had harm to that account, you're writing a check. Writing a check and making that call a week after you've onboarded a new client, that's bad, in case there's any question.
Yeah, I think, to emphasize what Kevin was saying and what Wendy was saying as well, is that, I think that, you pointed out the portfolio management, you pointed out portfolio compliance. Really, you got to get the buy-in. You have to have time to review the contract. The salespeople, make sure that they get that to you in a timely manner. A lot of things, our process is kicked off by the sales group who brings the client in. Then it goes to legal, and it gets circulated to a number of different people and departments. But you want to make sure you get it timely, and that was something that we really kind of focus on and work on to make sure that portfolio management, portfolio compliance really have the time to dig through those IPSs and understand what we can do from an operational standpoint, what we can do from an investment standpoint, what limitations that brings. And that way you can, if you want to or if you can go back to the client and talk about, we do it this way, you're suggesting it this way, we think this may be better if you give us a little bit more flexibility here because of X, Y, and Z. And so we want to make sure that you understand what your limitation does. Sometimes even the wording, it may not be clear. So you may have an interpretation of what that means. They may have a different interpretation. So reading through these things allows the different areas to raise points that may not be clear just on the face of the contract, to go back to the client before launch, to say, what can we do? We think that this is how we're interpreting it. Is this what you mean by it? And we want to make sure that we set this up correctly.
I'll put one more spin on that. This is a real opportunity for you to be a business differentiator in your organization too. You're not just coming to these questions as a compliance person. You're trying to help get the deal done. You're trying to help educate the client. you're trying to help play matchmaker, air traffic controller to interpret terms of art or language that isn't necessarily everybody's on the same page. This is an area where you can really help wearing a business hat and not just a compliance hat.
So a question for each of the panelists. So I just talked about frequency of monitoring. So do you folks include in either the IPS, the contract, or in your Form ADV, the extent to which you're going to monitor the client's account and have conversations with them about what's going on in the relationship?
So often that is outlined in the contract, and it's certainly in our standard contract. So we have standard reporting that we do. And so we also outline in our Form ADV how frequently we're reviewing their account specific to their investment objectives and restrictions. We have a monthly restrictions monitoring committee that meets to review the restrictions for all the clients in our strategies. And that's how we handle it.
Yeah, I think a lot of it is client specific. The client may want a monthly report. They may want a quarterly report. They may not specify. From a compliance monitoring standpoint, we're monitoring it actually daily. So, we feel that we have, some comfort around that. From a client reporting standpoint, again, a lot of times that is going to be more client specific, and that would be outlined in the contract.
One of the things for those of you that have a lawyer background, don't forget, this isn't just SEC regulation. When we're talking about IMA, this is a contract. So there are things in there that describe your agreement to trade goods and services for consideration, all that kind of stuff. If you breach that agreement, you have a contract breach. It may not be an SEC issue. You have a breach of your contract. And those breaches could be things that are as easy as, hey, I need a monthly report. I expect your portfolio managers to come and do an in-person meeting with me every 6 months. Those things aren't really compliance issues, but that's part of the bargain that you've struck with that client. And if you don't follow through on those, again, the FCC might say, yeah, that was kind of a naughty thing you did. You could have been sharper. But the client is going to say, wait, you put me in an awful position under my contract. I couldn't then talk with my CIO or my board. So you need to think of it both in terms of contract and in terms of SEC regulation.
And I think that's a great point. It goes back to my other point about 20647, compliance policies and procedures. Why didn't you have, under the circumstances, why didn't you have a policy and procedure to confirm what was in the contract and making sure that you were monitoring all the aspects of the contracts? Reps, warranties, agreements, everything could come back to a compliance issue.
And so I just outlined a few people that we send it to, but there's several other people that really need to review it because they have accountability at your firm for various sections of them. So another group is the traders. There's trading provisions that are often put in the contracts, and if it's a non-standard contract, there may be directed brokerage, there may be soft dollar provisions, and you need to make sure that your firm can comply with what you're being asked to do.
My favorite for the traders is get me best execution, but also direct my trades to here, here, and here. I have these targets, but make sure you get me best execution. Those are the things you identify up front and say, hey, is that something that we can actually live with, work with?
Then also the client service group needs to review it because there's several client reporting obligations that are in these non-standard contracts. They need to get captured and they need to be accountable for providing the reporting that's required by the contract on an ongoing basis. We also send it to our operations team because there may be specific provisions relating to proxy voting or custody that we need to capture. And then finally, legal and compliance review it for SOC 1 obligations, mock SEC exam obligations, regulatory communication notifications, as well as other legal reasons to review the contract. And then finally, some contracts have security requirements and for the IT team. And it's important that you have the IT team review those contracts that have IT requirements for them.
I'm going to stop for 1 second. One group that you mentioned that I think gets overlooked sometimes is the operations group. One of the things, most institutional clients will come to you with their custodian that they work with, which may not be the custodian that you normally work with. And you want to make sure that you have all of the connections with that custodian. You need to understand what that custodian can and cannot do from an investment standpoint. We've had some instances on our emerging market side where certain custodians don't handle the foreign securities the way that we would normally handle the foreign securities, settling them and the like. So it's making sure that, again, people within your organization have the opportunity to ask the questions to make sure that they have time to go out to that custodian and say, we do this or we do that.
Or maybe they can do it, but it takes them 2 weeks to set up the local country account in Botswana or wherever you're going to trade.
Right.
There's just one other thing I want to highlight that's really important, because once the contract is done, it's important that you provide to the people who are responsible for the different provisions what their responsibilities are under the contract. What we've utilized at our firm is a searchable contracts database. And the way that it helps us is it makes sure that we have every restriction cataloged, whether it's investment restriction or trading restriction, but also reporting obligations, because we may have a reporting obligation that's not required by SEC rules and regulations, but may be governed by the contract. And an example of this occurred back years ago when some of you may recall the lawsuit that was several lawsuits against different investment managers involving settlement claims in class action lawsuits and filing for settlements, filing claims in those class actions. And it's important to know what your client contract said regarding that, and we had to go through all of our contracts to read through them to see who we had obligations to actually file class action settlements, and luckily we didn't have any obligations to do that. But it's helpful to catalog everything in the event something novel comes up so that you can quickly run through everything in the event of a situation where you need to make a notification.
But even that's a super critical point. If you've got your intake right, you know whether your firm is being asked to take on the responsibility of class actions or advising on legal things. And we've seen in certain circumstances contracts that make it look like we're giving legal advice, we're making legal decisions, or we're providing accounting decisions or advice. And at the intake, that's when you identify those things and say, wait a minute, we're providing investment advice. We're not providing you legal advice or accounting advice.
Just as a postscript to those lawsuits, the plaintiff's firm, which really brought them, lost all those claims, so it didn't go anywhere. But we're going to move now to due diligence, and Jeff is going to talk us to practical applications of due diligence. Again, for me to set the table in the legal context, again, this is really important for you to establish the contours of the relationship. So that's the legal table setting. Turn it over to Jeff.
Sure. So due diligence, when you're talking about client onboarding and institutional clients, there's two real aspects. There's what due diligence you as an advisor, need to take for your client, and there's also the due diligence, as the advisor, what you're doing to, with your own service providers and things of that nature. But the other side of it is, what due diligence is that client doing of you? And how do you help that client get the information that they need? Because due diligence is really a way of making sure that you have taken an appropriate look at everything that's going to impact the relationship. The concepts of due diligence are listed on the slide here. That you need to have due diligence when you are selecting investments for your clients. And again, that goes to what we were just talking about with respect to understanding what their investment restrictions are and what their expectations are. And then it's also, what if you're outsourcing any part of your responsibilities, making sure that you have a process to understand what those service providers are providing to you. And on the next slide, we go through a number of things that the SEC looks at in past due diligence sweeps. They look to see, do you have written policies and procedures? Do you have a list of staff that's involved in the due diligence process? Is there information concerning any third parties involved in the process? A list of all of the investments reviewed under the procedures, a list of the funds reviewed and rejected and the reason for rejection. So if the client, doesn't like, some of, again, I'm going to point back to, investment restrictions here. The client most likely is coming to you to invest in certain types of strategies. So it's your job to make sure that they understand what those strategies do, what the normal investment guidelines on those strategies are, and if they have restrictions or they don't want that strategy, they need to make sure that you understand that. Copies of written questionnaires used for investments, and this is typically you are the recipient of those questionnaires. The client is coming to you with either an RFP, which we'll talk about soon, or on an ongoing basis, a due diligence questionnaire where they want you to respond to different things about the performance, about any changes within the organization, any violations, etc. So I'm not going to walk through every single item on this page, but the one thing I do want to mention here is really a concept that we've kind of discussed already, which is, use this due diligence process as much for your sake as for the client's sake. Understand what that client wants. Understand where they're coming from. Really make sure that they understand how you do business so that there are no surprises. So it goes back to our initial discussion of full and fair disclosure. You want to make sure that that client is comfortable with the services that you are going to be providing and that you understand what their expectations are. And I don't know if anybody else wants to jump in on the due diligence side.
I have something to add. One of the problems I have with our institutional client service team is when something is sent to me, and to other people who are part of the due diligence process throughout the firm, they're not clear about what strategy and what product is being pitched or is the existing product for the client. And that strategy or product is key to providing the right response. And so head this off, my recommendation is to head this off before any, in connection with any them seeking responses to questionnaires, as well as in connection with client meetings and due diligence meetings.
I have a question. Where do you find that the responsibility for the due diligence process lies? Is it within the client service team or the compliance team? Do you know?
That's a great question. At our firm, it's in the client service team.
Repeat the question.
Oh, the question was, where does the responsibility for the due diligence lie? The due diligence, is it in the client service team or is it in the compliance team? And at our firm, it's in the client service team. So we really do partner closely because we want to make sure that the end product is exactly what they're looking for. If I'm reviewing the questionnaire at the very end, which I typically do, it may be all wrong because they asked the wrong people for answers to the questions. They want to ask the fund admin versus the operations team if it's involving mutual funds.
But diligence comes in all shapes and forms. So we use our client service team to be the air traffic controller, and if what they're asking is cyber, then the client service team can reach out to the cyber team and get a good answer. It's not a compliance issue. They don't have to come to me for approval. They can go right where they are. Or if it's a diligence that involves an on-site meeting, I may be part of that meeting, but compliance doesn't need to be involved in helping to organize the logistics. I'm there to help and oftentimes if they don't know who else to ask, they come to us and the client wants to talk about this. Where do I go with that? Who can help me with that? And the poor client service person is looking for someone that they can put in the agenda to talk about that topic. That's often where we come in to say, well, we don't really have that particular thing, or our business model doesn't do that, or what they're really asking for is this, and maybe if we had Bob and Sue in the meeting, they can help address. So we end up being a consultant to the business a lot of times rather than air traffic controller.
Yeah, that's the same for us as well. I don't know how many times I get questions where the client service team will forward questions from the RFP or from the due diligence question to compliance, and I'll be like, that's really not us, and redirect them. But again, it's not really necessarily, at least in our firm, our responsibility to track down the right answer and to fill it in. It's really to make sure that the client service team has the information to get the correct answer, and then reviewing the requests and the questionnaires as appropriate.
One thing I do find really fascinating is going through this process, you do see opportunities to do compliance testing, because clients or prospects will ask really interesting questions that you haven't thought of before, and you may not have written procedures for them, and a light bulb may go off, and you may think, this is a place where we need to have written procedures. Or, we probably do have a process for it, it's just not in writing.
And this is not a legal or compliance comment, but I think the need for good due diligence procedures is really important for the business side. You just don't want to be that business who enters into a contract with a client that is a sketchy client or that will bring embarrassment to the firm. I mean, so I think that's a common sense and a business point that I've seen clients make mistakes when they haven't done their due diligence appropriately. All right, so we're going to move on. Kevin's going to take the next two sections, which are both related, Section 15C as well as RFPs. And again, my role is to set the table from a legal perspective. Section 15C is outside of the Investment Advisors Act interpretive release. Congress basically said that you have to do this. Advisors boards can request information that they believe is reasonably necessary, and advisors have to produce the information. So that's outside of the interpretive release. You have to do it. RFPs, the legal table setting for that is that RFPs can be viewed as an advertisement. This is something that the SEC could interpret as that could be inconsistent with your obligations under the advertising rules. The RFP also sets the contours of the relationship, which is what was espoused within the interpretive release. And I think also the RFP squarely fits within the full and fair disclosure concept of the duty of loyalty. So those are the legal concepts that the next two topics Kevin's going to discuss.
So the way that I think of Section 15C is if you're a mutual fund shop, 15C is just a really complicated RFP with a lot of technical mumbo jumbo in there that you have to do every year. But it's effectively an RFP. So we try to run it through the same type of process we would with any other RFP, but I will admit I provide a little more care and feeding, a little more involvement, just because some poor RFP associate that's trying to do the best they can doesn't have a chance of telling you what a material compliance matter is. So that is an area where folks like us or practitioners like you can help the business, because if they respond to a 15C with generic answers that don't address what the 15C is really looking for, that's going to look really bad, because your client's going to look at you and say, I thought you knew how to manage mutual funds. Why are you giving me an answer like that? Yes, ma'am.
So just have maybe a tactical question on that. Is there a difference in your review process within legal compliance for 15C versus a standard RFP questionnaire? Transparently, for 15Cs, I insist that we review every word on every page if it's going to someone else's on board. It slows down the process, but we feel really strongly about that. Just curious sort of how you guys address it.
So before the practical guys come in here, let me chime in and just give, again, a setting the table. So the SEC has said during exams that they are going to tick and tie the 15C letter, and I send out on behalf of my independent trustee client letters. They're going to tick and tie the letter to the response. And so they're going to make sure that a question that has been asked has been fully answered. And so not that we didn't do it previously, but we're really making sure in our role as counsel to independent board members to make sure that the ticking and tying is done. So as I've set the table now, guys, go ahead and answer.
So the answer is going to depend. I'm sure all three of us are going to have slightly different answers to that. My general rule is I do not require review before it goes out the door of any RFP. The ones that are higher risk, I reserve the option to jump in. So if I have a 15C, I am more likely to say, hey, make sure I see that before it goes out, but I do not write it into my compliance policy and procedure that I must review it before it goes out. But I reserve the right.
Right, and in our shop, anything that requires my signature gets reviewed by both myself and somebody on my staff. 15C requests generally will have our legal department involved as well. So generally I'm not doing some type of certification on a 15C, but again, to Kevin's point, there are a lot more questions that are a lot more detailed about compliance in a 15C. So I will usually be more involved in a 15C compliance response. But legal is usually doing the more fulsome review.
That's actually a really interesting point. It's a very good point, and when we do our RFP responses, we have an RFP team in client service that breaks it up, and they distribute out various questions of various subject matter experts, and then they unfrankenstein it. They put it back together again. So I will definitely have seen the legal and compliance questions as part of my role as a subject matter expert. Then what Jeff's talking about is that second layer. Holistically, do you have a look at the whole thing? So, I'm sorry.
So I actually look at the whole thing. We had a request from the client service team that I review every RFP. And I also review the 15Cs because I'm the fund CCO as well as the advisor CCO. So if it's a sub-advised client, I'm reviewing it from that angle. And if it's a fund, if it's one of our funds, I'm reviewing the 15C. We do run our process a little different. So the RFP team handles all RFPs, and then our fund admin team runs the 15C process, but I have wed them to the RFP team so that they get answers, that are consistent with what we're providing our clients, our other clients.
And just from my perspective as outside counsel, I know I've sent out so many of these letters and I've reviewed so many responses. I will know if compliance hasn't been involved, or if marketing hasn't been involved, or if other groups have been involved. It's subtle, but you will know the care and detail that shops put into their 15C responses, and it's really important.
So I'll pick on the wisdom of your week in the life of a CCO panel, but one of the things that I do that doesn't show up in any box score is that when there's a new joiner to the RFP team, I'm typically going to sit down with them and we're going to chat about what 17J1 is. They don't need to become an expert, but if they see 17J1, I want them to know that that's a defined term and that means something. That material compliance matter doesn't mean anything that goes bump in the night, like that means something. So they don't have to necessarily know the answer, but they have to know that that means something. I walk them through the difference between an exam and an SEC action. Those two are very different. So again, those are things that from a training point of view, I don't drill into training policies or procedures, but that's part of my diplomatic efforts to make sure that the people involved in the plumbing and the process are armed enough so that they can do some issue identification. I want to go back to something that we talked about earlier with contracts. I think there's an interesting mix. One of the weird things that you'll see in contracts every once in a while is that you'll get a prospect that puts their form of IMA in the RFP itself. And so it's kind of a weird leveraging, negotiating, tactic, strategy thing, because you have to provide comments to the IMA not knowing whether you've won the business or not, and presumably they're going to make decisions whether they hire you on the legal comments that you give to their proposed form of IMA. So that's something that does even add another layer of stress, anxiety over the sales and marketing process, and really brings those two areas together.
And that underscores how important it is for the RFP team to get those RFPs to you as soon as possible so that you flag all those issues and can do the proper due diligence in connection with responding to the RFP.
So every RFP is different. Even among 15Cs, different legal counsel have a different take. They focus on different things. Every RFP is different. When I started in this business, RFPs were more about actually pitching for business. It certainly shifted. You're still pitching for business, but we use the same plumbing on normal, ordinary due diligence questionnaires that arrive on a quarterly or annual basis, but they are all over the place. Some are short, some are long, some, I have people ask me, you still see questions, are you prepared to comply with the upcoming regulation of 20647? You can tell which ones are copy, paste, right? But you can see other ones which are much more, and these are the interesting ones. They're harder, but they're interesting, where clients that actually want to, hey, what are you working on? Here's something out of the headlines. How have you addressed this? So it's not the kind of thing where they're calling you on the morning and saying, hey, I'm freaked out about this, but they use it to get information. Many of my institutional clients, I'm one of 20 clients or 20 advisors, 10 advisors that they have. I am information, I'm data. They can do their own little sweep exam by putting a question in that quarterly questionnaire, and only that one quarterly questionnaire, that gets them back 10 responses on something pretty quickly. Again, so those clients are pretty interesting because they're being thoughtful, and their questionnaires are going to be different every quarter. So the timing is huge. Typically, the RFP teams are crushed. Typically, no one appreciates how much time and energy it takes to un-Frankenstein and re-Frankenstein. Typically, no one on the sales side understands the difficulty of actually finding the right person to opine on that thing. All of that happens. So I take the RFP team a little under my wing at times to kind of protect them. I'll go back to the salespeople and say, okay, who's buying drinks for the RFP team? You guys just slammed them with a big RFP and only a day to get it done. We'll get it done. But guess what? Somebody's buying lunch for that team. The RFP team may not be able to stand up for themselves and push back a little bit. I can. So I do at times. So you kind of take care of those that are involved in the process. But they're all different. So every firm is going to organize themselves in a little different way. One of the questions that comes up here goes, how do you actually get RFPs if you're actually pitching for business? And they can come from all different directions. For public clients, oftentimes they get posted on a public website. Anybody can see it. Anybody can decide, okay, I want to send an RFP in to manage XYZ strategy for public pension fund ABC. Public, anybody can do it. Those very, very, very process formula. They have blackout times. They might have periods within which you can submit questions. Typically, it's going to be difficult to actually talk to somebody in their procurement team while that RFP process is underway. Those kind of things happen, but very, very structured. And those can be extremely complicated because not only the contract, but the RFP can be a generic procurement exercise. It may not be tailored for investment management. It may not be tailored for a service. It may actually be generic enough that it could apply to buying a tangible thing. So going through that, and then there's a bit of creative writing. While I know your question asked for this, I think what you're really looking for is this. Let me provide a diplomatic way to answer what I think you're trying to get at and apply it to the service that we're trying to provide. And those are things you just can't cut and paste a generic RFP response.
But to that point, I think you, in our prep sessions, you made a good point of just because there's a question being asked, don't always feel like it needs to be a response. Sometimes it's not applicable. Sometimes really it's not on point. They're asking the wrong question. They are, and you can try to interpret it, but don't take it too far is what I would say. You want to make sure that you are responding to the questions as well as you can as they are asked, because some of it it will go off in a completely different direction.
Why don't we jump a slide or two ahead here? I'll just make a comment here, and Jeff mentioned this before, and Wendy did with IMAs. Same thing, RFPs, they can cover the breadth of your firm. Everything that your firm does is fair game to be asked. Now, whether you want to answer it or how you answer it is a different question. But when you think about it from a client or a prospect point of view, they're thinking of it from 100 different ways, everything from very tangible investment returns to very abstract reputational risk concerns. They can ask everything that they'd like. Jump one more there. And then just a couple of practical items, and these are things that if you're in the trenches, these are probably second nature to you. But we're going to talk about due diligence or meetings in a second. The better you do on the RFPs, the more smooth those meetings typically go. And I've had circumstances where a prospect walks in and says, I've read your RFP responses, that was awesome, I just want to talk about these two things, and I'm out of here. you've leveraged their time. You've made it easy for them to get their job done. I've had other people that after submitting a big honkin' RFP, they walk in and they physically want to go through every question and revalidate everything that's in the RFP. Client's always right. So whatever you want to do, no problem.
One key thing for that is when you do have that meeting, you want to make sure all the players who are in the meeting have read the RFP before going into that meeting, so that they're
Absolutely.
consistent with what they said originally should be the answer to those questions.
Absolutely.
Which is a good segue for Jeff to talk about.
One more
Oh,
question
I'm sorry,
in the back.
question,
ma'am.
yes.
So this is actually more about existing client GDP question, but have any of you had experience with a larger, wirehouse kind of client who sends DDQ requests that are electronic and you're not able to keep a record of how you responded?
The short answer is yes. In the old days, somebody would send questions, we would populate them and send them back a PDF. We still do that in most cases, but there are some clients that have moved to more of an online portal where you upload answers into that portal. From my experience, as typically more existing clients doing quarterly, particularly mutual fund clients, where they're trying to keep track of 40 sub-advisors, it becomes mechanical. What we typically do is we will run that process through our standard process, and that'll end up in a kind of a shadow email or Word document, and then we'll cut and paste those things into the portal.
We actually take pictures of the database and save that.
That would have been my advice. Questions?
Really quick, do you actually, at the start, where sales is bringing this RFP, are there decision rights at that point where you might actually refuse, or the business might say, I don't think this is one we should complete, and is there criteria for that?
It's a great question.
It is a great question.
Repeat the question.
So the question was, are there instances where you get an RFP and the business believes that this is not the type of business that the firm should take on, and how is that handled?
Yeah, we had a similar situation to that come up actually just recently. It was an existing client with a due diligence questionnaire, but they were asking just really in-depth questions about personnel and all sorts of kind of confidential information that we would not give to a client. And we went back to the business because HR, legal, and myself were all very uncomfortable on providing any of these responses. And we went back to the business line and said, is this worth it, to upset the client by not providing the information? Is the business worth it? And the business came back to us, and in this instance, they said, you do what you feel is right for the firm, which is the right answer to do. And if we lose the business, we lose the business. And we went and we worked with the client and their consultant, and we were able to find kind of a midway point where we weren't giving them what they had asked for, but we were able to provide certain responses that were responsive to their questions.
I'll add one thing and then we'll move on to physical meetings. I think one of the keys is issue identification and escalation. There might be questions that are maybe not a black and white, but the firm takes on some additional risk by agreeing to that business or agreeing to that provision. So it's a question, it may not be, we may not have a veto, and we may not like it at all, but ultimately, could we do it? There's no legal reason why we can't. I don't want to do it, but there are senior people that make decisions on behalf of the firm all day, and part of our job is to identify, escalate, and provide a recommendation. But ultimately, if from a business point of view, they want to take that burden, take that risk, set that precedent, there is that's a business call, as long as we're not violating things and getting ourselves in jail.
Question?
Yes, what system or process do you use to actually track requests? Because they typically don't come in one. They typically tend to cluster around, and a lot of them recur from year to year, especially with sub-advised relationships.
So ours are manual. We track requests manually currently, and we're looking to do it through technology.
Yeah, I'd say our client service team, tracks them manually, but they have a system and I don't know if I can say system names for antitrust purposes, but they have a system to library their responses, past responses, so that they can find something that may be similar, and it allows them to answer the questions a lot easier and get something that is at least a starting point for people to look at.
I don't mean in terms of a database of past responses, but the actually tracking, like we received this request on March 15th and it's due on March 22nd.
We have every week our client service team will send out a list because it was a problem where they would be sending you things with like a 2-day turnaround. So now they've sent every week they send out a list of upcoming things that are going to be due within the next week or 2 or 3.
Yeah, my RFP team keeps their own queue, but the gentleman's agreement there is if you get something that's a super rush or something is going to be a big deal, give folks downstream a little bit of a heads up. We'll come running to help, but get us ready to come running.
Physical meetings?
Yeah, physical meetings. So we were talking about the RFP process. Usually the RFP process, one of the last pieces of it is the physical meeting. And in the physical meeting, I think we've touched upon some of the points here, but there's no requirement for a physical meeting. There's no law that says that the client has to do it and you have to provide X, Y, and Z. But you want to make sure that again, from a due diligence standpoint of your own, making sure that you understand who the client is and what their requirements are. You want to make sure that to the extent that the client has requested an in-person meeting, that compliance and the appropriate people are at that meeting. So again, it's working with the client service group, making sure what the agenda is, who the appropriate people are, setting that agenda, making sure that the client has input on that, and really making sure that you have all the right people in the room. But one of the things that we were just talking about that I think is really helpful, know what the strategy is. Make sure that, because I know in our firm, we have strategies that have different custodians and different, processes. Our equity strategies, they participate in soft dollars. The fixed income strategies do not. So, just making sure you know what you're going to be talking about, because, you can fill out these RFPs, but a lot of times the people that are coming to do the on-site, sometimes they haven't even read the RFPs. That's for a different group. So they're coming with their own set of questions. And, to the extent that you know what the client is or who the client is and what strategy they're investing in, and as a practical matter, you should be reviewing the RFPs to know how the firm has responded. But, they, as Kevin said, they may say, great, we've got other questions. Other times, they don't reference the RFP at all, and they just come in with their own standard questions. What we like to try to do is make sure that, it's an interactive process, because, you want to make sure that you are responding to the questions that they need to know. There are certain clients who come in and they just want you to tell them about your firm. For me, it's not as an interesting of a meeting. It also, we prepare a presentation for all clients. Some clients just want us to walk through that presentation. We try to engage them and try to make sure that, we're answering the questions that they want, because just walking through this may give you a flavor for who we are and what we do, but it's not going to answer the questions that the client necessarily has.
This really is an area, if you're looking for areas of professional, personal development and growth, this is a key one. Do your prep. The difference between a good compliance officer or a CCO and an excellent one, the excellent one knows exactly why that client's there. Are they happy? Are they unhappy? What's the background? Were they a former client? Did they come back? Do they have particular issues? Did the individuals, maybe the client's been around for a long time, but the people that are coming today are new to that firm. They don't have the background. An outstanding CCO does that work and can walk into that meeting and add value for the business and not just be there as, if you have questions, I'll answer your questions. An excellent one will have that prep. An excellent will have the diplomatic skills to be able to handle somebody that doesn't have English as a first language or is new to the industry. And those are the differentiators that makes, that you can really add a lot of value instead of just talking about doing a client meeting, doing it well.
Your point reminds me of another useful tool to have for these meetings that we use, and that is our institutional client service team takes notes of all meetings, and they provide us with the notes of the prior meetings. So you have context, oh, maybe your kids went to college together. But in addition to that, you know what kind of questions they asked last time and how to be better prepared for the meeting this time than perhaps you were last time.
Or little things, like, did you actually meet with this person last time? If you go into the room and this person walks in, hey, how you doing? Good to see you again. And you're like, I have no idea who you are. That's one flavor,
That's
right?
key.
That's right.
Yeah, so just those little interpersonal skills that help.
And those notes are all discoverable, by the way, so beware.
One other thing
That's true.
I would mention about physical client meetings is the client's always going to ask, did you have an exam recently? Do you have any litigation? Make sure you can respond to those.
Greatest hits.
Yeah, make sure that you have that information. Whatever we'll get to things where you can and can't provide certain documentation, but at least respond to the questions and be able to walk them through those types of things.
So we're rapidly running out of time, so I'm going to whiz through the compliance policies and procedures because I've already mentioned it. Again, I'm not saying that you should adopt it. It depends upon your business, but it may be a good idea to do so. And we're going to segue right into this sensitive information, which Jeff was talking about. Again, if you look back at my sitting at the table, nothing really, duty of care, duty of loyalty, and sensitive information. This is all business decisions in coordination with counsel, compliance, and your business leaders as to whether you want to produce sensitive information. When clients come to me with these type of questions, my answer is it always depends. How much do you want the business as compared to how much is the giving the sensitive information that important or that difficult for you to do so? So that's my sitting at the table. Any comments from the folks here?
I just, seeing cyber up there just jumps out at me. Things like this, you'll get generic questions. Have you had any cyber issues? What does that mean? Does that mean that the person that clicked on the dumb link and we had to reimage their machine, is that a cyber issue? Probably not. That was dumb, but we didn't have any leakage of client information. So when you respond, you try to reframe or to be clear about what the parameters of your response are. So that's an area where if you elect to be really, really transparent about every little thing, that's a really high standard to maintain. And from a competitive advantage point of view, you could make your firm look a lot worse if you're providing every little thing that went bump in the night. So having some degree of reasonableness, commercial reasonableness, regulatory reasonableness, when you address those kind of questions, that's important to have as you provide advice to your business.
Yeah, one of the weird questions that we get, it's not a weird question, it's a standard one. Is there any litigation involving anybody, any of your principals or officers or employees? Well, we may have employees who are undergoing a divorce and there's actually litigation relating to their divorce. That's not germane to the questions that they're asking. Or they may have a lawsuit relating to their condo association, not germane to the relationship. So we try to redirect our answer to respond specific to our business.
Yes or no answers. You get really, really bad SEC deficiency letter that is embarrassing, and a client in an RFP asks for it. Do you disclose it? Yes or no?
No. You can disclose the content and talk about the content, but the letter itself, no.
Ditto. It would be an in-person conversation with either myself or the general counsel.
Let me rephrase the question. It's a $100 billion account.
No. You can come into my office and see whatever you want. I'm not sending letters out into the public.
Agreed.
100 billion.
Same.
Okay. All right.
100 trillion.
Fiduciary duty, Alan.
Hey,
Treat all clients the same.
I'm just asking the questions here.
But here, in all seriousness, this is a good example. When you have good letters, maintain that same standard. You can't just maintain that principle when you have a tough letter.
Well,
So-
Absolutely.
And also, I mean, it is a little bit of a curveball question because you're dealing with really good organizations up here. And I deal with smaller clients at times where they're going to make that judgment call. So you have really good, large organizations up here. It's different for a smaller advisor. I will definitely submit that.
But back to what makes a good CCO as opposed to an outstanding CCO, that question right there, the credibility that your firm loses if you try to play games with those kind of things. If you try to play games and your salesperson says, oh, that looks bad, I don't want to show that, or that looks great, I'd love to highlight that, the credibility that you can offer there, that's the kind of stuff that really makes differences.
So we are just about out of time. So I wanted to ask Wendy to talk about our last subject matter, which is termination. So we'll terminate the session here with Wendy talking briefly about how do you go about terminating client contracts in a way that is consistent with your fiduciary duty.
So I think the outline says it all. I think things to be careful about are trade errors on termination, so that the communications are coming from institutional client service team to the trading team and the portfolio management team so that they're not engaging in a trade error. You will have books and records obligations following the termination of the contract. Any questions on that? Or anything else?
Just never forget that a terminated client is a prospect now.
It's true.
So, but that was a good one. I like that. So with that being said, thanks, and particularly thanks for this folks for the questions. It is our pleasure to be up here, and we appreciate your time. Thanks very much.